Okay, in today's video, I want to take a look at the law in Ireland surrounding powers of attorney. There's two different types of power of attorney, and it's very, very important that you're clear on what they are and what the powers are and how they're circumscribed and so on. So let's take a look. Firstly, what is a power of attorney? A power of attorney is a legal document which allows a person, the donor, to give powers to another person, that is, the donee or attorney, to take certain actions on behalf of the donor. There's two types of attorney or power of attorney. One is a power of attorney, or sometimes referred to as a general power of attorney, and the other is an enduring power of attorney, and they are quite different things. So the general power of attorney or power of attorney, the ordinary power of attorney, it can only be created by a donor when he's not mentally incapacitated and he understands fully what he or she is doing. It can grant a specific power, for example, to buy or sell a property, and it can also give not just a specific power but general powers to the donee. The key thing, though, is that the person who is giving the powers, the donor, understands what they are doing. If the person becomes incapacitated, then the power of attorney ceases. There's a form to create a general power of attorney. It can be found in the Powers of Attorney Act 1996, and it can be found online on the Irish Statute Book. So if you just Google Powers of Attorney Act 1996, scroll down to the very end, you'll find a schedule or an addendum to the Act, and it actually gives a brief note or precedent for a power of attorney. As I say, it can be specific or it can be general. An example of a specific power of attorney would be where I was acting for a client, an Irishman who had gone and emigrated to Australia. He wanted to buy a property here, and to make matters convenient, he gave me a power of attorney, or actually, he didn't give me the power of attorney. He gave his father-in-law the power of attorney to act on his behalf. So the father-in-law then, after I drew up the power of attorney, he could come in and he could sign the contract and sign documents to do with the bank and so on in relation to the purchase of the property. That was a power of attorney with specific powers. It could also be general. An enduring power of attorney is a different kettle of fish completely. It comes into being when a person is incapacitated. It allows the attorney or the donee to make personal care decisions on behalf of the donor when the donor becomes mentally incapacitated. It's a much more complex process than setting up an ordinary power of attorney. You're going to need a doctor and a solicitor, and the document creating the enduring power of attorney must follow a certain format. It must include a statement from the doctor that the donor had the mental capacity to sign it at the time it was signed and understood the effect. It must contain a statement from the donor to the effect that he knew the consequences of creating the enduring power of attorney. And it must include a statement from a solicitor that the donor had the capacity to make the enduring power of attorney and that the donor was not acting under any duress or undue influence. After creating the enduring power of attorney, two people must be notified of the making of it, and these people cannot include the donee or the attorney. One of the notice parties must be a spouse or civil partner, and if there's none, a child must be notified. If there's no child or spouse or civil partner, then a relative must be notified. The enduring power of attorney only comes into force when it's registered. This involves an application to the Registrar of the Wards of Court in the High Court, and this can only be made when the donor is or is becoming mentally incapable. So the enduring power of attorney is set up prior to the person becoming mentally incapable, and it only comes into effect essentially when they do become mentally incapable. There must be a medical cert confirming that the donor is incapable of managing his affairs, and the High Court has extensive supervisory powers in relation to the enduring power of attorney once it is registered, and the High Court can also revoke or cancel it in certain circumstances. The powers of an enduring power of attorney then Well, it can give general powers, including personal care decisions, to the attorney, or it can give specific powers. All decisions must be taken in the best interests of the donor and the donor's family, and carers must be consulted. Personal care decisions would include things like where the donor should live, their dress and diet, who they should see and not see, management of their financial affairs, personal health issues, and so forth. A donor can revoke the enduring power of attorney anytime before it is registered. However, if it's registered, an application must be made to the court to have it revoked, because remember, once it has been registered, it's assumed that the person, the donor, doesn't have the mental capacity to revoke it. An enduring power of attorney then ceases on the death of the donor, and there are also some other limited circumstances where the enduring power of attorney will be terminated. The relevant legislation, as I say, dealing with powers of attorney is the Powers of Attorney Act 1996. And that's the act that I spoke about earlier, in which you'll find a form to create a general power of attorney. You might be interested, there's my contact details there on the screen. If you find this video useful, please give us a thumbs up down below, and you might be interested in subscribing to my channel. If you are, just hit the subscribe button.